one essential element of defamation, which is that the words must refer to the plaintiff. So the plaintiff must prove that the statement or the words refer to him. So this is one of the things that he has to prove, that the statement or the words complained of refers to him. So the plaintiff can be mentioned by name, or the plaintiff can be mentioned by description. Yeah. So either way, whether it is by name or by description, you have to prove as the plaintiff that the statement refers to you as a person. So if the plaintiff is mentioned by name, then there is usually no difficulty about this, and there is no requirement that the defendant should have intended to refer to the plaintiff.
We need these people to be quiet.
But can you tell the people, I'll be putting those names of this class,
yes,
all the time. I'll be recording their names, and of course they must at some point face some consequences.
Yeah, this cannot continue.
It is very wrong for someone to come to this class and start talking without any plotting. Yeah, I'm saying that if the plaintiff is mentioned by name, then there is usually no difficulty about this. And there is also no requirement that the defendant should have intended to refer to the plaintiff. So if the plaintiff is mentioned by name, anybody with that similar name, or with a name similar to that of the plaintiff, can bring a suit of defamation. It does not matter that the defendant did not refer to this other particular person who shares a similar name as another plaintiff. So you must mark this. It is the responsibility of the author or publisher of this statement to ensure that the statement he or she is making is not capable of referring to any other person with that particular name. So in a case where a name is used, anybody with that similar name can bring a suit and succeed on defamation where names are used. Even where description is used, if there is a plaintiff who is capable of explaining how that particular description is capable of referring to him, he can successfully bring a suit on defamation. So we have a case here of Halton and Company versus Jones. Halton and Company versus Jones. In this case, the defendant published an article in the newspaper which purported to describe a motor vehicle festival in Dieppe. There's a place called Dieppe. So they were purporting to describe a motor festival in a place called Dieppe. So in the article, they described the activities of one person called Artemas Jones. This Artemas Jones was a church warden in Peckham. And some imputations were cast on his morals. So they were describing somebody who in their mind was fictitious. To them, the publisher, this person was fictitious. It was called Artemus Jones, who was a church warden in Peckham. And they published an article which had some imputations on his morals. So this person was intended to be and was believed by the writer and the editor of the paper to be purely fictitious. But in fact, there was a barrister or a solicitor who was also called Artemus Jones. And this person was not a church warden at all. And he did not even live at Peckham and had not taken part in the Dieppe festival. So he sued the company for libel. And his friends swore that they believed that the article was referring to him. Though you see the publishers and the writers had all along believed that this person, Artemus Jones, is fictitious. Unknown to them, there was another Artemus Jones who was. So the verdict was given plenty. The verdict. I'm saying that the verdict was given for the plaintiff, and the House of Lords refused to disturb this because he had
Esther.
Well, I'm saying that the verdict was given for the plaintiff, and the House of Lords refused to disturb this because in the lower court, they had found for the plaintiff that the plaintiff, who was called Artemus Jones, was defamed in this particular statement. It did not refer to him, but simply because the statement used a similar name like his, he was successful in a suit for libel. The House of Lords held that if reasonable people would think that the language to be defamatory of the plaintiff, it was immaterial that the defendant did not intend to defame him. So that is the most important thing that I need you to understand. Where names are used, you don't have to have intended to defame a particular person. If the names are similar, you will be held liable unless you take steps to ensure that your statement will not be capable of referring to somebody else with such similar names. I hope that is very, very clear. No requirement that the defendant must have intended to refer to the plaintiff. Then, if the statement is true of one person, but defamatory of another of the same name or description, then you will still be held liable on the statement being defamatory for that other person. This was decided in the case of Newstead versus London Express Newspaper Limited. So in this particular case, an article in the London newspaper was entitled Harold Newstead, 30 years old Camberwell man, had been convicted of bigamy. That was the statement. Harold Newstead, 30 years old Camberwell man, has been convicted of bigamy. That was the statement. So this statement was referring to a self-confessed bigamist called Harold Newstead, Camberwell barman. This guy was a barman in Camberwell. The plaintiff, who was of the same name and was a barber working in a barber shop. So the plaintiff, who was of the same name and a barber and lived in Camberwell, brought a libel action against the defendant. So the defendants argued that they had not intended to refer to the plaintiff, but they were referring to another Harold Newstead, who lives in Camberwell and who was in fact convicted of bigamy. But the court held that the defendants were liable to the plaintiff because they should have taken greater care to ensure that their article would not have been taken as referring to someone else. So this is very, very important. Where names are used, and in cases where you did not intend or had in mind any other plaintiff, you need to take care to ensure that the statement could not be taken to be referring to someone else.
But the same he wanted a copy of another type or another record.
I hope so far so good. We are proceeding nicely. No interruptions.
We are proceeding nicely, but there is some noise activities behind either a student or your station. I don't know if you can have the people in charge to mute. Thank you, sir.
So there is no requirement that the plaintiff must be expressly be referred to by the defendant. It is sufficient if the statement impliedly refers to the plaintiff. So if the statement impliedly refers to the plaintiff, that is sufficient for finding a suit on defamation. So you don't have to expressly refer to the plaintiff. If there is some implied meaning that could be discerned from the statement, and the plaintiff is capable of showing that the statement impliedly referred to him, he would succeed. This was shown in the case of Morgan versus Adams Press Limited, 1971. It was a case about some dog doping gang, and a girl who was alleged to have been kidnapped. This lady had gone out swimming, and she disappeared for some time and reappeared. And it was alleged that she had been kidnapped by some dog doping gang. So the plaintiff claimed that he had been libeled by the defendants in an article concerned with a dog doping gang, which had allegedly kidnapped a certain girl. So I want you to get the gist of this particular case. At that relevant time, that the lady was alleged to have disappeared by the paper, the girl was staying in the plaintiff's flat. The girl was staying in the plaintiff's flat. And the plaintiff produced 6 witnesses who testified that they thought that the article was referring to the plaintiff. And they were thinking that the plaintiff is also involved in the activity with this dog doping gang.
You can't force someone.
I want you to get here.
Me right now.
This innuendo. The court held that there was sufficient evidence to go to the jury because the ordinary reader who had special knowledge of the circumstances would conclude that the article referred to the plaintiff, because at that point, the girl was staying in the plaintiff's flat. But at the same time, they wrote that this girl had been kidnapped by a gang, a dog doping gang, which was wrong, but the girl was staying in the flat belonging to the plaintiff. So the plaintiff sued the defendant, saying that, you see, anybody with this special knowledge that the girl was staying in his flat, and they had reported that the lady had been kidnapped, would think that the plaintiff is also involved. He is one of the members of this gang, and therefore hiding this lady in his flat.
Tomorrow at 3 on Starlight.
Is this very clear? Is it clear?
I did have a heart, but there were no feelings. I did have sleep, but
Is this clear? If it is clear, I would want to invite some questions from you.
today. Well, you are already in love with Kirtan. I want you to dedicate yourself completely.
I have a question concerning that you said that they have the publisher has to care to make sure that that there is no conflict. Could you please explain the care that we have to take?
Well,
Not yourself in this game.
the care which you have to take
Friends won't hurt
is
you.
to indicate.
I originally entered the Mitchell family as a bride, right?
Hey, what is wrong?
You're number one.
Starts tomorrow.
You have to give some proviso. At some
I
point,
can't hear you. There's too much.
We are hosting the prayer meetings in this house now.
can you talk to those people?
What's going on in this house? Devaki, I planned the meeting for you. What I mean is, it's for the entire
Marina, I have a suggestion.
day.
If you can ask your IT person,
God, I
your
told her
person, that person, and just remove them from class because they're watching TV and then they're interfering with the class.
Yeah, these guys are not even paying attention. They would notice if they were paying attention.
Exactly.
Are you able to detect them from your side?
Yes, Maudim.
Yes, we can see their names.
Can I get those names because they need to be warned? Because it's not good to really just interfere. Yeah, it's like they come all the days prepared just to interfere with us. Because if we will not be having problems with them today.
Mwalimu,
Can you question?
Mwalimu, you can call for the last time before you get the names. You can call them to order, or you can allow the class president to call them to order.
Yeah, the class president, you have the permission to call them to order at all times.
Yeah, and in this case, Vincent Murimi, kindly mute.
I have a question.
He cannot mute because he's not paying attention.
Sir,
ask the question.
I didn't get the case well, the one that you talked about, the girl who disappeared and then reappeared because there was
the case is Morgan versus Odam. Are you seeing the presentation?
Yes, I can see it.
The Morgan versus Odams Press Limited.
Okay.
Any other question? Okay, the lady was asking how you take precautions to ensure that the statement is not referring to someone else. It is only perhaps in your wording that you ensure that if the statement would be referring to someone else, you need to put it ipso facto that it wasn't your intention to refer to those persons, and again, you don't know of any other circumstances that would make those statements refer to them. Of course, these are some of the unintentional defamation which we are also going to see at the end of this particular lesson today, where you unintentionally, because of course there is no way in which you can take such precautions to ensure that that absolutely your statement does not refer to someone else. But there is a way in which the act has come in to, of course, aid the people who unintentionally defame others. So there's a provision of the act that is now there to safeguard, and there are conditions that must be met so that your statement can be put as in the class of unintentional defamation. There are some conditions which, if your statement does not meet those conditions, then it would not meet the threshold for it being unintentional. But we're going to see that at the end of this particular class today. Any other question? Are you okay? We proceed.
Yes, sir, we proceed.
Yeah, let's proceed. So let's look at defamation of a class. Defamation of a class. Can a person sue in respect of words directed against a group or body or class of persons?
Recording in progress.
So that is the question, whether a member of a group or a class of people are able to sue on a statement which is directed against that particular membership. So that is the question. Yeah. So there is this case which has looked at this particular issue, the NUPFA versus London Express Limited, where the plaintiff here was a Russian refugee, and he was a member of a Russian party, which had 24 members in Britain. And he was the leader of this particular party. But there were several thousand members of that party abroad. So the article referred mainly to the activities of this party in America and France. So the article alleged that these groups are Nazis. So the plaintiff, who was a leader of the Britain group, brought an action against the article, that the article was defamatory of him. So the court held, the House of Lords held and explained that the plaintiff could sue in respect of this statement if he could prove that the statement was capable of referring to him and that it was in fact understood as referring to him. And in this particular case, it was held that the plaintiff could not show that the article was capable of referring to him as a person. So it was also held that normally where the defamatory statement is no individual belonging to the class is entitled to say that the words are written or spoken of himself or herself. Thus, a class cannot be defamed as a class, nor can an individual be defamed by a general reference to the class to which he belongs. So this has to be very clear. No individual person can sue in respect of a statement directed against a class. A class cannot be defamed as a class, nor can an individual be defamed by a general reference to the class to which he belongs. There's a case in point here, the Eastwoods versus Holmes, where it was said that if a man wrote that all lawyers were thieves, no particular lawyer would sue him unless there was something in the words or the circumstances under which they were published, which indicates a particular person or person. Again, if the reference is to a limited class or group, for example, maybe 5 people, 10 people, for example, trustees of a particular class or members of a firm with not so many members, less than 10, or tenants of a particular building, so that the words can be said to refer to each members, then in that case, every member of that group will be able to sue on that particular statement. And this, I would want you to look at the case of Brownie versus E.C. Thompson. So you can look at that particular case where if the membership is not that big, that you could say that now the statement is capable of referring to each and every member of that particular group, then an individual or person can sue on behalf of that or in regard to that particular statement. But where the membership is as big, then no particular person or member of that group can sue in regards to that statement directed to the group.
So I have a question.
Yes, question
regarding the numbers. In this case, the one about the Russian refugees, they were 24.
Yeah.
What point will they be able to sue or not? Maybe less than 20.
In this particular case, there were 24 in Britain, and there were other 1,000 members in other jurisdictions. And again, the statement was referring to the activities of this group, especially in America and France. Not even in
Britain. 41 minutes, 15 seconds.
I mean, if the number perhaps is less than 10, for instance, then any member of that particular group can
أنا كمان إذا بتي بالانس كشيء ما قاعد فول ما لا بقى العتول ولا دينا
لما لا تقدر اسمي ذا خشنا إني كل كيد بنا هذا إذا هذا صار العمر زمان أنا
يوسف محمد شيك
نجوا هذا باش شغال ماشي مريض يو جماعة إذن شيء
يوسف محمد شيك يوسف kindly mute.
Well, any other question? Yes. Proceed.
I have a question, Mwalimu.
Yes,
the number large. What is a measure? Large, is it by numerical number or by significance? What is this meaning of large number?
The largeness is the number, the arithmetical, the quantity.
But you see, Mwalimu, if you say, let's say in Uganda, where I come from, if you say professors there are mad, there are many professors compared to another place, let's say place Y, where there are only 2 professors. So for those places, 2 professors, 2 is a large number. For us, with about 50. So isn't the numerical problematic because it depends on many other factors within that environment to give that numerical numeracy material significance?
Well, if you say that professors in Uganda are mad and there are only 2 in Uganda, we will not refer to professors in Kisumu. We will just be looking at those professors in Uganda and we say there are 2, and therefore the statement is capable of being defamatory against each of those professors because there are only 2 there. But where there are more than 20 or more than 10 professors in those regions, then no professor can say that the statement was referring to him and not any other professor. But where there are 2 or 5, I believe the court will understand that such a statement is capable of referring to each and every one of those professors.
So Mwalimu, just a follow-up to that. If you say probably from the example that Steve has given, that professors in Siaya are mad, and then maybe there are 50 of them, and we decided to group up as the 50 of us and sue the person who was, made that statement. Is that actionable?
So, a class cannot be defamed as a class. That is the rider. A class cannot be defamed as a class. So if you go as 50 professors, that is a class. You cannot be defamed as a class. It is just an individual within the class. So it is the individual who will have to explain how that statement is capable of referring to him as a professor in CI.
So what is rationale behind the law saying that a class of people cannot be defamed?
You see, this is a tort against a person and not against a group. We are also not trying to restrict people from talking about something which is in the interest of the public. You know, when it's about professors and or lawyers, you know, it's the interest of the public would want to know what's happening. So you cannot bring a suit to gag freedom of speech on matters which are very important for the society or people, unless you can show that you yourself who is aggrieved, the statement was referring to you as a person, and therefore your reputation is endangered.
Hello?
Yes.
I have a question, Malim.
Yes.
In terms of, my question is, could a defendant use apology as a defense? This is, for instance, if a media house publishes a defamatory statement, then which of course might have gone a loss for like a period of 1 week. And then by the time I'm filing a court case, they go ahead and issue an apology in the media houses. Would that act as a defense? Would my case stand?
That's what we are going to next. Now.
Good, thank you.
Excuse me, sir. In the above incident, what if there's a representative body that, for instance, for the case of Eastwoods versus Holmes, if it were in Kenya, the Law Society of Kenya, if it were to sue, does that suffice?
The Law Society of Kenya, if it involves about its governing, the governing reputation of that particular body. So the body can sue because it is a body that has a name and also has property. So it's got a name that it should protect. Yeah. In that case, you know and understand that it is capable of suing in its own name. But what we say, no person in that group of lawyers can sue or over a statement that refers to the membership of the Law Society of Kenya as such. Are you getting it? Unless it shows that there are some circumstances in which those statements could be understood to be referring to him as the aggrieved person or plaintiff. Yes? Anybody else? So let's proceed. Let's look at unintentional defamation. So, liability for an imputation which is defamatory of the plaintiff does not depend on the intention or knowledge of the person responsible for the main publication. So, liability does not depend on the intention or knowledge of the defendant. Yeah. Defamation may thus be unintentional, as in the cases of Cassidy, which we had looked at, Halton, and Newstead. And such cases may produce hardships, especially for the writer of fictions and their publishers. Hence, a change in the law was introduced by the Defamation Act, which applies to any defamatory words innocently published. Now, we have the Kenyan Defamation Act. If you go to section 13 of that act, it provides for statements which are innocently published, and it gives conditions under which statements can be classed as being innocently published. And if you have innocently published a statement, then the law allows you to make amend and apology. The law allows you to apologize in such situations, including, of course, publishing such apologies. And the law says that if the plaintiff accepts the apology, then the case lies there. But if he does not accept the apology, then the apology now becomes a defense against any suit for defamation on that particular basis. But there are conditions which must be fulfilled. So the provisions of this act applies to any defamatory words which are innocently published. And it provides that words are innocently published where the following conditions are satisfied. One, that the publisher did not intend to publish them of as concerning that other person, and did not know of the circumstances by virtue of which they might be understood to refer to him. So it is only under
lakini nategemea na place. Australia inasema Laura vizuri. Australia. Ati nategemea na geographical location yako, kuna wenye wanasema Laura na kuna wenye wanaita Laura.
Olivia, mute.
There was a girl in our class.
Okay, let's proceed. So the provision of the Act applies to any defamatory words which are innocently published, and it provides that words are innocently published where the following conditions are satisfied. And innocently published words, I've told you, are in the sense of apology. You are apologizing for having published words which have become defamatory of a person whom you didn't have in mind or never intended. So this apology, if it is accepted by that party, then the case ends there. If it is not accepted, then it becomes a defense to mitigate the damages that the court might award in that particular case. And you are encouraged to read section 13. So one of the conditions is that the publisher did not intend to publish the statement as of concerning that other person. And he did not know of the circumstances by virtue of which the statement might be understood to refer to that person. Or, number two, that the words were not defamatory on the face of them, and the publisher did not know of circumstances by virtue of which they might be understood to be defamatory of that other person. And in either case, that the publisher exercised all reasonable care in relation to the publication. So if you read that section 13, you'll understand. So these provisions would apply to cases such as Halton, Newstead, and Cassidy. So where this section is applicable, the defendant can discharge his liability by making an offer of amend or apology and amend. So an offer of amend under the provisions of the Defamation Act is an offer where the defendant apologizes for a defamatory statement which he has made, and it is not a complete defense, but will have the effect of mitigating the damages for which he is liable. So under the provisions, an offer of amend is an offer in any case to publish or join in publication of a suitable correction and apology. And where copies of documents or records containing the words have been distributed by or with the knowledge of the person making the offer, he must also offer to take such steps as are reasonably practicable on his part to withdraw them from circulation. So if the offer of amend is accepted by the aggrieved party or by the plaintiff and duly performed, no proceeding for libel or slander may be taken or continued by that party. But if the offer of amend is not accepted by the aggrieved party, then it is a defense in any proceedings for libel or slander against him. Any question?
Yes, I have a question, Malimu.
Yes.
The offer of amend, does it mean acceptance? So that then that offer would be self-incriminating to the defendant. Thank you.
Yeah, you know very well that this person did not intend to defame this plaintiff. So he has offered an apology. He is apologizing. The law allows him to apologize in situations where he did not intend to defame a particular person. Yes, he's accepting that I have defamed you, but I did not intend. The law allows such an intentional defamation to be corrected, to be apologized. Is that clear?
Yes, it's clear.
So that if the plaintiff accepts the apology, then no case lies. If he does not accept the apology and the person has apologized within the law, then that offer of amend or apology will be a defense against any suit on defamation.
I have a question.
Yes.
Yes, Mwalimu, I have a question following the issue to do with apology. When are you allowed to apologize? Is it after the case is filed to a court or before? When exactly are you allowed by courts to apologize?
When now the defender, when now the plaintiff brings to your attention that perhaps the words are defamatory of him, in that instance, you offer an apology because you have to say that I did not intend to do that. And again, it is within the provisions of the law that you can do it at that point, because it's only at the point that you find your statement is defamatory of a person, that is when now you can make an apology. You cannot apologize in vacuum.
Question, Mwalimu.
Yes.
Mwalimu, is it true that if you want to sue one for defamation, you must first of all write a demand letter. And if you write a demand letter for the defendant to apologize, then in such a situation, the court would not award you any compensation. That the demand letter is a prerequisite for one to be awarded or compensation for damages.
Of course, any suit before you take any suit to court, you first of all write a demand letter. So if you can settle it without going to court, it's okay. That's for any suit, not only for defamation. So in case of defamation, also if you put that demand letter and again that demand notice, it is at that point that perhaps the defendant comes to know, wow, I've defamed, and then offer amend, because in that demand letter you will also say, if you don't apologize within this particular time, then things like that. So at that point, you can make an offer of amend.
Mwalimu, there's one part which I'm still not quite clear. You see, most people who defame others tend to do so and then they defame ignorance. Let me take an example, although that example is not particularly harmful because it is privilege. In Parliament, especially the National Assembly, if you watch the debate, it's apparent that often members want to impugn, to undermine the images of each other, but then they hide, of course, behind the privileges. And then the speaker asks one to withdraw and so on. But you can tell that the intention was to show something in bad light. Now, outside Parliament is the same thing. Most people who defame others do not mean well. So does it mean that this notion of an intention is a hiding ground where I can defame you, for example, a teacher, and then I feign ignorance? What is a measure of making sure that this seeking amend is not used to launder mischief?
Of course, if you look at the confines under which the law allows you to make amend, it is not a blanket, it's not a wide blanket. It is only within those circumstances in which the law can allow you to make amends. You see, where the statement on the face of it is not defamatory. Are you getting it? And therefore, you also did not know of any circumstance under which it could have been defamatory of that person, other person. You see, or in this case, you never intend. The confines is very clear, and it would be very difficult to find a maliciously made statement to fit within that particular confines of the law as it requires.
Hello, Malim.
Yes.
Just within an unintentional defamation, and whereby the defendant has apologized, but at the same time, the apology, he damages. damages due to the unintentional defamation. Will it mean that with an apology as the defense, the case will collapse? Or can the plaintiff go ahead and seek damages?
Of course, if it is genuine, the court will take that as a defense, and that will help in mitigating damages. Mitigating damages that the court will have to reduce, yeah, perhaps, and only give what we call nominal damages, but not those damages that are going to be reflective of compensation in that matter, because you apologized and it is within the law, but there's a person that refused, so the court will accept is right to refuse, but we're taking into consideration the offer of amendment to mitigate damages.
Well, how about, I've had this notion that
Thank you.
I've had this notion that
Mwalimu, please ask Chelsea to mute. Mwalimu, can't hear anything.
you have to demonstrate that you have a fame.
Mwalimu.
Yes.
How about if I declare that the person who is purporting that I defamed him have no fame after all? Would that be good enough?
Can you ask again?
There is this notion that for you to say that I've defamed you, you must have a fame.
Yes.
So how about if my reply is that you have no fame anyway, so how can I have defamed you? Is that good enough?
Oh, it depends. It depends. It depends why are you saying that he has no fame?
I'll give you an example. Let's say
you have to explain.
No, I give you an example. Let's say you are saying you're learned, but you have a degree from a polytechnic in the US, and that polytechnic, in my opinion, is not equivalent to any university of repute.
Yes.
And as a scholar, I believe so.
Yes.
Would this be a problem if I then stated what I believe within our club of scholarship?
Yeah.
We believe that what you call a university was a village polytechnic, and we've told you it's a village polytechnic, and then you say we've defamed you. Can I stand my ground?
If whatever you're saying is truth or true, it's a defense, truth and justification. So if you justify the statement, then that's a defense, a complete defense, if it is understood and accepted by the courts.
Okay, thank you.
Yes.
Excuse me, sir.
Yes.
What if the plaintiff takes the defendant to court without the defendant's knowledge that they had committed defamation? What happens in such a situation?
If
the plaintiff takes...
There's a procedure for taking someone to court, isn't it?
Yeah.
Yeah. So if you follow the procedure, the defendant must know, because he'll have to enter appearance, and entering appearance is preceded by some other procedural issues, which, as he said, a demand notice, etc., etc. You cannot just go to straight to court because you have been, I mean, annoyed or angered by that.
Yes, Mwalimu, I have a question. Is it really the fame of someone that we are guarding, or is it their dignity, or is it their reputation?
It is the reputation. I don't know how to define reputation, but it is the reputation of a person.
Excuse me.
Yes.
Okay, I asked a question on demand letter as regards the purpose of the...
I can't hear you.
Okay, I'm saying I asked a question regarding demand letter in cases of defamation. But when you are giving the response, I did not get the response due to network hitch. Kindly pardon.
Yeah, what I said is, when you get that demand notice, of course, it makes you become aware that you have defamed an individual. So at that point, if you make an offer of amendment, because even that demand notice would request or demand that you make an apology. So at that instance, if you make an apology, yes, if the plaintiff accepts it, then it's not going to proceed with the case to court. But if he does, then that offer of amendment will be used as a defense by the court. And if it is made within the confines of the conditions given, then it will help you as the defendant in mitigating damages that the court would award in that matter. So you will bring the offer of amendment as a defense. Yeah. That's okay.
That's okay, but Mwalimu, I have a question in addition to that. You know this gentleman called Miguna Miguna?
Yes.
Have you seen what he has been saying and writing and the labels that he has accorded certain individuals, especially the president and the former prime minister?
Well, they are within the law to sue him. Why they're not suing him is best known to them.
So now I wanted to ask a question.
Yes.
Now that they have not sued the two, if I did an article referring to the two as despots and conmen, as Miguna has done, and cited Miguna, can they claim that I have defended them? I will be quoting what Miguna has said, which they have not contested.
When it comes to truth and justification, you don't say it is true Miguna said. No. Is it true that he's a despot? You know? Yeah, are you getting me? Not true that Miguna said he's a despot. Is it true that really what he referred to is a despot? So truth and justification is not about the source of your publication. It is about that particular individual and the substance. The article referred to him as a despot. Is it true that he is a despot? So you have to explain that. Not that it is true, Miguna said.
Okay, thank you.
Yes.
Mwalimu Miguna is an authority.
Yeah, but what I'm saying is, you don't say that Miguna say, even though he's an authority, it is you who is now publishing it to others. So can you explain, you know, you're not an authority. You, not as an authority, can you get the truth of that substance about the despot? Not because of Miguna. Miguna is an authority, maybe he can explain, but what about you? Who publishes a sting of defamation? Because a defamation is a defamation, whether you are repeating what somebody had said. Are you getting it?
Hello, Mwalimu. Just following the case of Miguna, suppose you provide an explanation that maybe Miguna has given, maybe to say that the president is a despot or is corrupt. Maybe he has explained and used his explanation. Can it hold water?
If what he has explained is true and the court accepts that it's true, it is not you referring to what Miguna said. It is you finding or bringing as a defense truth and justification to whatever you say.
Even where there are, even where it is foreseeable that this message could be forwarded and repeated by others, by the general populace.
Unless you bring something that explains that your continuation, yeah, is not a publication, where you say something has intervened. Are you getting me? So that whatever it is that you're repeating is not a fresh act. Otherwise, if you don't have the explaining circumstances, you will be taken to have defamed. But we are going to look at where something has intervened and stopped the proceeding defamatory statement being published, not defamation. Yeah, are you getting it? Or we're going to see where what has been said is the necessary or is a necessary consequence of what is to be said, so that you become liable even for what you did not publish thereafter. But because you had done it before, it becomes a necessary consequence of what follows. So we are going to see the connection from right to left and from left to right. But not now. We still are not dealing with these defenses where you say, I am simply repeating. Yeah.
But question, Mwalimu.
Yes.
What about the media houses, Mwalimu? Whenever there is speculation regarding even the leaders who are involved in corruption, they publish. They can even use that. They can even reproduce the label in newspapers. So why are they not being held liable for defamation? Because they reproduce those labels even in newspapers.
What I'm going to show you later is the group of people who will become liable substantially and those who will become liable on the surface of it. Because, you know, we have a group of people. We have the author, we have the editor, we have the publisher, we have the newspaper vendor, we have all those things. We are going to see what are their liability extent. So we're going to see that one also. So if there is no question touching on an intentional defamation, I want us to stop there for this year so that we open up next year with the topic of the words must be published.
When is the first class? Next year.
The first class is the first, is it? Today is Monday. Monday is not a holiday, isn't it?
Oh, but third is too early, Mwalimu.
No.
3rd of January is too early.
Remember, your exam starts on...
Yes, we have exams.
On 17th.
Yeah, exams start on 17th, so it will not be pushed. So 3rd is not early, if you consider that one also.
And 3rd is okay, because
Yeah.
everybody, even children will be back to school on 3rd.
Yeah. So
That is defamation. That is defamation. How can you compare? That is intentional defamation there. Huh?
We are in school. We are.
Oh, we are not in school, we're in the university.
If let us proceed.
Doing what, Daktari?
What are we doing in school, in the university, Daktari?
Learning, not being educated, but learning.
Let me stop recording.
Excuse me, sir.
It's not supposed to be recorded.
Okay.
Mwalimu.
Yes.
Mwalimu.
Recording stopped.
I have a request, Mwalimu.
Yes.
Mwalimu, at times we do experience some network itches. So I'm requesting that you provide us with the recordings for the previous class and the today's class.
Yeah, I'm requesting it from Lamek. He's promised that he's going to send it to me. So as fast as he gets to a laptop.
Yes.
Yeah.
That is okay. Mwalimu, we wish you a Merry Christmas, Happy New Year. We hope to see you on 3rd, and we will try keep time. Please send the link before the new year so that we have it in our reservoir. Thank you,
It is this link. It is this link.
Thank you, sir.
Okay. So you happy Merry Christmas and a Happy New Year to you all.
You too, sir.
You too, sir.
Merry Christmas.
Merry Christmas and a Happy New Year.
Yeah, Merry Christmas is just 4 days to come.
Mwalim,
Yes,
sir.
mine is a request if it's possible, whether you can share with us the notes. I'll really appreciate.
Yeah, the notes are these things that you see in the presentation. Yes.
So is there a way where we can get even those ones?
Yeah.
Whether we
Is
can
there a
get
way?
where we can get even those ones for presentation.
Yeah, I'll try to send it or share it through your WhatsApp if you have one.
Okay, okay. Thank you.
Yes. So it's the end, as we have said so.